of last year. And through the Housing Advisory Committee, which was established as a result of that, those recommendations, we're delivering on the tenant workshop today. I want to thank Vicki Murray and Courtney Priest, two members of our Housing Advisory Committee, who really took the bull by the horns to initiate and organize the event today. And we hope you find it extremely informative. As we're all aware, we're in a housing crisis. We know that on a very frequent basis, people are being advised they are being evicted from their homes. And while sometimes that may be a warranted action by a landlord or property owner, there's also times we know when it may not be warranted and or due process is not being followed. And as recently as yesterday, I've heard of 9 or 10 people who are facing eviction under a renovictions strategy. And so it's important that people understand their rights and if at all possible, if they want to stay where they are, have every opportunity possible to stay in their home without being evicted. So I want to introduce Linda Tranter. Linda is a lawyer with the Legal Clinic, and she may have more information to share. But Linda has been an incredible resource. She spoke to our Housing Advisory Committee. I saw her speak in January of last year, pre-pandemic. And that really motivated us to say we need to get Linda in front of our public because she has incredible insight. She understands the law completely. She's a real advocate. And if there's an opportunity for someone to stay in their home, she will find a way to make sure they can stay there under the law. So with no further ado, I will turn this over to Linda. Welcome, Linda, and we look forward to your presentation.
Thank you. Thank you so very much. I'm just going to give you an idea what we're going to do today, just so folks understand what kind of the agenda is. We've got up to 2 hours. I know 2 hours is a long time to be online, so we may not use the full 2 hours. And you're, of course, welcome to check it out anytime you so choose. That goes without saying, I hope. I will not be offended, nor will anyone else. And the other thing is, we talked about questions. Questions are quite welcome, but there are a few things that we ask in terms of restrictions. First of all, your questions should be right on point. I am going to follow a PowerPoint. I know it's not for everyone, but in this format, I think it'll keep things moving in a organized way. There is time for questions, of course, but try to keep the questions on the topic because I'm going to try to cover all the ground and hopefully we'll answer some of them a little later in the presentation. And secondly, I very seriously ask you not to share information about your personal situation. I am very happy to meet with, speak to anyone who needs specific legal advice after this proceeding privately. You can call the Legal Clinic, I'll talk about that. But don't talk publicly here about your personal circumstances. I won't give specific legal advice. I'll just give general advice because this is going to be live streamed on Facebook and YouTube. And whatever you say here is going out to the wide world. And you can be pretty sure that a lot of other people are going to watch this, or at least I hope so. So anything you want to add to that, Mayor Pankow?
Yeah, and just, I guess, as Linda indicated, she'll go through a presentation. If you do have a question, please use the chat feature if you're comfortable with that. And there's of course the icons in the bottom or top of your screen that will enable you to chat. And if you do want to ask a question in person, use the reactions and raise your hand like I've done right now, so that we'll see your hand and we will call and that'll give Linda an opportunity to see your hand and take your question when she has a break in her presentation.
Great. Okay. So at this point then, I know Carrie's going to be a great help to me, and I'd ask you to pull up the presentation. Just give her a moment to get it full screen. So now, Linda? That looks great. And of course, I think we all know with these Zoom calls, you can be on camera or off camera, use the chat or raise your hand as you wish. It's totally up to you folks. And if you want to use a name other than your name that's listed, just right click on your name and rename yourself. You can call yourself whatever you like. Okay. Okay, so let me talk about the presentation a little bit. The purpose of today's presentation is to talk about primarily tenant protection, this tenant protection first aid, because there is no way I can tell everybody everything you need to know about landlord and tenant law. I have been working as a lawyer I've been at the legal clinic for almost 22 years now, and I've been doing this area law for 25. And I'm still learning every single day more things about landlord tenant law in Ontario. Anyone who thinks it's simple is deceiving themselves because it's not that simple. But I'm hoping to give you the basic principles that you'll need in order to protect yourselves and protect other people in the community who are tenants. Okay. So it's first aid. It's not open heart surgery. Okay. So I'll ask you to turn the page, Carrie. Okay. Before we get going, I'm going to talk a little bit about the legal clinic. Every county and city and town in Ontario has a legal clinic. So if you're watching us from some other part of Ontario, rest assured there is a community legal clinic in your area. Legal clinics are funded by Legal Aid Ontario, but they are independent, nonprofit, community-run organizations. We take our instruction from members of our community. We serve low-income people, and we do a real variety of things. You'll see the staff that we have at our particular legal clinic. We're 7 lawyers, 1 paralegal, 2 support staff. Actually, we don't have a community outreach worker at the moment. That varies somewhat over time. And we are governed by a volunteer board of directors. If you're interested in being on our board of directors, you're quite welcome to volunteer, as long as you live in the area. Yes, Mayor Pankow.
Yeah, Linda, can you please sort of quantify or clarify what you mean by low income? There's certain thresholds, I assume, that.
Okay,
income is
so that is a complicated question, but I'm going to start off by making it simple. It's a complicated question because our income guidelines, income and asset guidelines, depend on the size of your family. So there's a whole big chart. But I can tell you right now that it should not be a barrier. Our policy at our community legal clinic is that we provide free legal advice actually to anyone in the community that has a tenant question or an ODSP question or Ontario Works question or a question related to the services that we provide. So we do not ask for income information at the outset. We will provide free legal advice to anyone who qualifies. And when I say qualifies, it has to do with our area of practice. And after that, if we're going to be fully representing, that's the point where we have to do a bit of analysis of whether or not you would qualify financially for full representation. Okay, but suffice it to say that the income levels are set by Legal Aid Ontario, and they are very low, in my personal opinion. Okay, so I'm not going to get into that here. Insurance, basic wages, Ontario disability benefits, Canada disability benefits, old age security, etc. Okay, your right to housing. And that means your right to have your housing protected under the laws of Ontario. Your employment rights, human rights, and other essentials. Specific areas in which we practice, you'll see there. Income law, any sort of income. If you're having difficulty qualifying, if you've been cut off, if you have an overpayment, if you just need information about income law, please call us. Housing law, primarily tenant protection law. We're going to talk a lot about that today. We do not represent landlords. Landlords do not qualify for representation. And actually, there is another service for landlords that is free and funded by Legal Aid Ontario. It's called the Landlord Self-Help Center, and they serve the province. We do employment law, workers' compensation, employment insurance. We do some human rights work, primarily in the areas of employment and housing. We do disability rights work, health rights. We do powers of attorney and wills for low-income people. We do general advice about contracts, debt, consumer rights, fraud, things like that. What don't we do? We do not do family law. We don't do divorces, separations. We don't do children's aid law. We don't do criminal law, and we definitely don't do real estate law. The Legal Aid Ontario has a separate program where you apply for a legal aid certificate if you qualify income-wise to hire with a legal aid certificate a family law lawyer, children's aid lawyer, criminal lawyer, etc. You'll see the legal aid number right there. If you're interested, jot it right down, or it's very easy to find online. Any questions about that? I see the chat has a few comments. No, all good. Okay, next page then. All right, where do we work? Well, we used to be called the Lanark County Community Legal Clinic, and then we were the Lanark Leeds and Grenville Legal Clinic. And now we have so many letters after our name that we just call ourselves the Legal Clinic. That's our official name, but we serve Lanark County, Leeds and Grenville, all the way down to Brockville, Prescott, Gananoque, Westport, etc. We also serve the northern region of North and Central Frontenac and northern Lennox and Addington. So the map isn't quite accurate that you see here. We sort of have to cut it off part way because we don't go all the way down to Kingston. The Kingston Legal Clinic serves the southern area of Frontenac, Lennox and Addington. Next page, please. Our housing work. Okay, so we're going to focus at this point on housing work. As I said earlier, we will offer free legal advice on housing issues to all tenants regardless of income. We will also be happy to provide some basic advice to other members of the community, whether they be mental health workers, municipal workers, etc., if you're supporting someone who may have tenant issues. And when it comes to full representation, we have a priority system. The demands are extremely high. Okay, if you're not on mute, please mute yourself. So our priority is prevention of homelessness at the moment in particular. Most of the cases we take on are eviction cases, and we cannot take on every eviction case, but we do as many as we possibly can. The more complicated the case is, the more likely we'll assist you, and the more we also do an assessment of a person's ability to represent themselves when we decide whether we take on a case or not. If we don't decide to represent, we will provide significant legal advice to allow you to represent yourself as much as time allows. The other thing we do is we act as tenant duty counsel at all local sittings of the Landlord and Tenant Board. I'll talk about that in a minute, but right now all of the sittings are online for the time being. They're all on a Zoom platform, but you can use a simple telephone to dial into your hearing, and we will be there to assist you before anything gets going. And we'll stay and we'll do as much as we possibly can to assist tenants at those hearings. Okay, next page, please. All right, so we're going to go through this part a little bit quickly because I think that a lot of this is common sense. But one of the things that we realize every single day in the work we do is the importance of housing. This is from the Canadian Public Health. I got it off the Public Health Unit website, but it doesn't seem to, I don't know who created this graphic, but studies show that 50% of your health in Canada relates to your life conditions. So your employment, your housing status, your income, your ability to get basic necessities of life, and your sense that you are supported and included in your community. So at least 50% of what makes us sick has to do with the conditions in which we live. And this is this is based on all sorts of health studies. These are the social determinants of health. You'd be surprised to know that 25% relates to how much healthcare you're getting, 15% is your biology and genetics, 10% is your environment, which also includes your housing, I'm sure. So housing is critical. Next page, please. This is the way I look at housing. Housing is a lot more than housing. A happy home is not merely having a roof over your head, it's a foundation under your feet. There's nothing more important than safety and shelter. It is the most fundamental determinant of whether or not you'll be able to live, whether you'll be happy, whether you'll be safe, whether you can raise your family, whether you can function in any other area of your life. And we certainly don't see homelessness as homeless people as a problem. Homeless people are a symptom of a much bigger problem. Turn the page, please. Housing crisis in Lanark County. Now, I've done some research and I've looked at the wonderful research that's been done by Lanark County. Lanark County has done quite a few surveys, but unfortunately, the most detailed information we have about the number of people who are renters and the percentages that they spend on their income is still quite old. It's the 2016 census. We are waiting for last year's census to get posted. I don't think it's out yet. But it's fantastic because it tells us what percentage of people are renters. In Lanark County, we believe that 21% of households are renters. I think that's gone up, but I'm not certain. And we'll know in about a year. And as of 2016, almost 49%, almost 50% of households paid more than 30% of their income on housing. I think it's a lot higher than that now because the average rent then was $952 a month. And though we haven't done surveys, a general survey of housing listings, which I do quite often, shows that rents right now have gone up to, for an apartment, usually between $1,000 and $1,600. Oh, thank you, Ms. Mayor Pankow. According to the last census, 42% of Smith Falls residents rent. So that's not surprising. And I think, as I say, rents have gone up from $952 a month, and that was an average for all of Lanark County, not just Smith Falls. I think they were a little more reasonable in Smith Falls historically, but our rents have gone up to over $1,000 for a 1-bedroom usually, and $1,500 for a 2 or 3 bedroom, and probably $2,000 for a house. And that's just a rough estimate based on the survey of listings that I've done. Wait lists for subsidized housing are going up at all times, and we'll talk about that in a minute. And 1-bedrooms are the most requested. So inaffordability is a huge problem. My cartoon is not terribly funny, but I fear that some of us are moving into the tiny cardboard box 1-bedroom. And that is something that no one in our community wants to see. Next page. I'm just seeing a small question from Pauline Levesque. I believe the last census, 2016 was the last results, but there was a census last year. And they haven't released the results. We're really looking forward to getting those. Hopefully it'll be out sometime in the next, I don't know, next year or so. Again, these figures are old, but it shows the increase in percentages of a person's income that tenants are paying in Lanark County. So you'll see a steady increase in percentage of income. So our incomes go up rather slowly, and rents have gone up much more quickly. And these figures, I would predict that the next bar in each of these graphs is going to show a much, much higher percentage being paid towards rent, unfortunately. That's certainly the trend I'm seeing. Next page, please. Sorry, next page, Carrie. Thank you. Quickly, Lanark County has done some great work around surveying the causes of homelessness. And at the bottom, you will see unable to pay the rent is one of the leading causes of homelessness. I would certainly say that that has increased. Now it does say other reasons, and you'll see a small list of reasons. Certainly there are other reasons, but the number one reason is usually unable to pay the rent. The second one, interestingly, is conflict with a parent or guardian. So that would typically represent young people staying at home and not being able to stay in their family home, young adults or older teenagers. And the third one is domestic abuse. And there's certainly many other reasons why people may become homeless, but financial is a big one. Next page, please. Affordable housing. Well, we know the waits for affordable housing are very long. These times are not up to date either. I believe this is 2018 or 19. I'm sorry, I don't have it in front of me. But the waits in different communities are really quite high. These are days. There is a tenant waiting up at the top there for his subsidized housing, and I don't think he's going to make it. But I would say, unfortunately, the wait times are going up. At the same time, that our municipalities and Lanark County have been working hard to try to do whatever's possible to increase subsidized housing or public housing in our communities. So I won't be talking about those initiatives today, but I know that the message is getting across and people understand that we're in a real crisis. Next page. Okay, our goal at the Legal Clinic is to prevent evictions and protect safe, affordable housing. We work together with community partners, and the key is timely advice and referrals so that the sooner we give advice to tenants, the more likely you'll be successful at your hearing. So as soon as there is a threat of eviction, it is very appropriate to send tenants to the Legal Clinic. I'll be talking about how to do that shortly. Next page, please. Okay, let's get down to the nitty-gritty, what you came here for. Evictions 101, a quick course on how to avoid eviction if you're a tenant or if you're helping a tenant. The very first principles are the following. First of all, you cannot be evicted in Ontario unless you have a hearing at the Landlord and Tenant Board. Many people call me and say, I've been evicted. I say, what do you mean? They say, I just got a piece of paper. And I say, you haven't been evicted. You just got a piece of paper. So let's talk about it. Now, it is possible to be evicted from a private home if you share the kitchen and bathroom with the owner. So if you rent one of my bedrooms, which aren't for rent right now, but if you rent one of my bedrooms and we don't get along, yes, you could be asked to leave without a hearing. But other than that, there are very few exceptions. There is one process in Ontario and one process only. And if you are a tenant and you get a notice of eviction, you have a right to see the process out. You have a right to stay. You have a right to get legal advice. And you have a right to be heard in front of the Landlord and Tenant Board of Ontario and explain yourself. And I'm going to talk all about that in the next few minutes. So tenants can only be evicted, actually evicted, after a hearing of the Landlord and Tenant Board with proper notices served. Then they cannot be evicted until an order is issued by the Landlord and Tenant Board, and the decision belongs to the Landlord and Tenant Board member, not the landlord. And finally, you can only be removed from your home after that order is issued by the sheriff and no one else. So even if you have an eviction order in your hand, you will not be removed until the sheriff of the court, the Superior Court of Justice, comes, gives you a warning, and then comes back on the appointed date. So a lot of folks feel that it's a bit like television. The sheriff may just come knocking at your door. It is not like that in Ontario. The sheriff does not just come knocking. Your landlord cannot just come knocking. And they can knock and they can talk, They can give you paperwork, but you cannot have your locks changed. You cannot be removed from your housing without proper processes. And I indicated here that the fines are $25,000 for an individual who throws the tenant out without due process, or $100,000 for a corporation. It is a punishable offense. So if you're threatened with eviction, it is not an eviction. It's just a threat, and processes must be followed. And that's where you want to refer somebody back to the legal clinic for advice. Okay, next page. Okay, so in addition to there being only one process to evict tenants in Ontario, there are very specific legal grounds. And if your situation does not fall under these grounds, you cannot be evicted. So if you are a rent-paying tenant who is following the law and not causing serious interference with other people or serious damage or anything like that, your landlord cannot just ask you to leave for no reason. These are the grounds for eviction in Ontario. Now, there's a couple other obscure ones that you're not likely to run into. If you run into them, call the legal clinic. These are the main ones. Obviously, failure to pay rent, and I add, with no workable repayment plan. Repayment plans often run to a year or more. You may be $4,000 behind in your rent, but our advice still is set up a repayment plan and we will help you to do it. There are second chances. You could be evicted for persistently paying your rent late. In other words, pretty much every month for a long period of time. If that happens, your landlord could apply to the Landlord and Tenant Board, and almost always the Landlord and Tenant Board will say to you, okay, the next year you are going to pay your rent on time every single month. And if you do that, you won't be evicted, even though you were late in the past. So usually what we see is a conditional order saying pay your rent on time from now on. If you breach that order and you're late on your rent after your Landlord and Tenant Board hearing, well, then you're in danger of eviction. And again, get legal advice. Serious damage to the property, but you have a chance to fix it. Not fixed in time or not fixed at all. So I use the word serious because you do not get evicted for wear and tear. You do not get evicted for accidental damage, which can happen. You don't get evicted for minor damage that can be fixed. And you always get a chance to fix the damage and repair the situation. How is wear and tear defined is a good question. Well, wear and tear. I mean, there's no legal definition of wear and tear, but if it's something that would normally happen, like in your home, I mean, invariably floors get dirty, floors get worn, eventually they might need to be resurfaced. Everything has a shelf life. You can't expect linoleum to last 50 years, even though I've certainly seen 50-year-old linoleum. Things happen, things wear out. You're not going to be evicted because things are just wearing out. You get evicted if you start smashing things. Most definitely that could be a problem. Or you do something very foolish and negligent and you're not willing to fix it. Okay, so wear and tear is just normal stuff. And a landlord has an obligation to keep the place up to code and reasonable, unless you broke it. And then the obligation shifts back to you to fix or pay for. I hope that answers your question. There's no really, really clear cut. It's real common sense. Illegal activity in the home must be serious. You can't be evicted for not having a dog license. Okay, you can't be evicted for any illegal activity that happens outside the home. Otherwise, anyone who got a criminal charge would be immediately evicted. No, that's not the law in Ontario. Okay, it has to be something so very serious that it affects your ability to live in a building or a home in a way that would be tolerable for your neighbors or your landlord or the other people in the building. So again, serious illegal activity, that is an area where you want to get legal advice right away. It is something that we would take on usually, that we would represent on a lot of the time. Again, serious damage to property also. Next one, serious interference with or endangering other tenants, noise, safety, antisocial activity. This is a very common ground to receive a notice, but not as common to actually result in a full eviction. Get advice immediately. It's a matter of degree. It has to be serious. It has to be not fixable. And a lot of people with serious interference or with serious damage to property, you do get two notices. You get a first notice, which is a warning notice, and you get a second notice, which is you didn't stop. You didn't fix it when we asked you to. So serious interference with other. Oh, I'm hearing somebody.
Hello, it's Don Robertson. Okay, listen, I can't get you on my computer for some reason, but are these all Canadian rules?
Okay. This is Ontario only.
Okay.
Okay. Ontario only.
I'm sorry to interrupt you.
No problem. It was a perfectly reasonable question. All right. Serious interference. Again, get legal advice. I consider those matters. Actually, get legal advice for all of these. Call the legal clinic anytime. And if you are not in Lanark County or Leeds and Grenville, then you should call your local legal clinic, because the legal clinics in Ontario all do tenant protection law. Okay, the last two are more interesting, perhaps. I say interesting because they're more difficult, perhaps. The last two grounds are the landlord, immediate family member, and that is child or parent only, not sister, not cousin, needs to live in your property as their normal home for at least a year. Now, we're seeing a lot of these. This also includes not just the landlord, but a buyer of the property. So a lot of folks are getting notices right now in Lanark County and Leeds and Grenville because somebody is purchasing the property. You do not have to move out because the property is being sold. You only have to move out if the property has sold and the new owner will be living in the place as their normal family home. They cannot have three other properties that, they don't, if they have another home, you cannot be evicted because the house is sold, nor can you be evicted because the landlord doesn't like you and says they're moving in. If they live somewhere else, they can't live in your house. Please call us. We're beating a lot of these, okay? Because some of them are fraudulent. In other words, the person may or may not require this rental property. The other thing is a landlord cannot require you to move out in order for them to move in if there are 4 or more units in the building, or so if it's a fourplex in an old building, you cannot be asked to leave because the house is sold or because the landlord is moving in. The other thing is if your new landlord or your old landlord owns the building with a corporation. So they may have a little corporation to protect themselves from liability. A corporation does not live in a house for normal family purposes. A corporation cannot use this section. There are a lot of different rules about this, so it's a lot more complicated than meets the eye. There are specific requirements for compensating you, paying you extra money to allow you to move. Get some legal advice. And then demolition and serious repairs are both possibilities, but there are very specific rules about when serious repairs can be grounds for eviction. Those rules include it must be so serious that you cannot live there during the renovations. And we all know that most people, if they own their house, do all kinds of renovations around them. And maybe you don't have a bathroom for 2 days, maybe you don't have a kitchen, but that doesn't mean you have to leave your home. And it would also require a building permit. And there's some very specific rules as well about your right to move back in following renovations at the very same rent with the very same deal. So please get legal advice. If you see a notice like this, do it quickly. There's a lot we can do. You may think that there's no possibility of staying, but I am telling you that a huge number of these applications will fail when they get to the Landlord and Tenant Board. I would say more than 50% for sure. I can't give you numbers because we don't keep stats on things like that. Maybe we should. What are not grounds for eviction? End of your lease. That doesn't mean anything. It just means you go month to month with all the same protections that every other tenant has. End of lease means nothing. Sale of property is not grounds for eviction. Your landlord is welcome to buy and sell the property as many times as they want, and you are part of the package. Same rent, same deal. Changed my mind is not grounds. Not getting along, disagreements, conflict, not grounds for eviction. Minor lease violations, your boyfriend moved in, your grandma moved in, you got 2 dogs, not grounds for eviction. And any other reason not listed in the Residential Tenancies Act is not grounds for eviction. Okay, so that's a huge area of questions. I'm just wondering if there's any questions on these issues. I am going to talk about processes in a minute. And I just remind you, don't talk about your personal circumstances. Any other questions? Okay, if more questions come to mind, please feel free to let me know at any time. Next,
I have a question. Okay,
go ahead.
It's Don here again. Listen, the have to look at the the rent, subsidies, and so on and so forth. Like, I mean, right now, I'm paying $8.85, and I have nothing but $11.55 for income.
Mm-hmm.
And I've been on the waiting list, for subsidized housing, for 3+ years, but they're telling me it's 7 years maybe.
Yeah. This is a very, very good question. Is it Tom, you're saying? Your name? Don. Sorry, Don.
Don Roberts. Don, yeah.
Okay, so Don, this is the biggest challenge that folks in our community are facing right now, is that just complete unaffordable rents. A couple things I would suggest to you. If you're low income, you'd be very well advised to contact Lanark County. Be happy to give you the phone number, 267-4200. Okay.
I've got it. Yeah. Thanks.
Okay. Or if you're not in Lanark County, contact your local municipality. There are some portable rent subsidies and other temporary subsidies that can make it more affordable to live where you're living. And the wait lists for those are not nearly so long. So what they basically do is give you, I believe it's $200 or $300 a month towards your rent. And I'm not saying you're going to be on the top of the list, but those things have been very, very helpful. Lanark County also has a catch-up fund. We call it the HOP program, the Housing Options Program. Every other municipality has a rent catch-up fund as well. They're all different. So you'd be well advised, if you get a little behind and you're having difficulty making ends meet, to contact your local county, Lanark County, Leeds and Grenville, whatever. In our case, it's Lanark County. And see what else is available to tide you over until affordable housing might be available to you. Other than that, if you get behind in your rent, as I said before, repayment plans are the norm right now.
Okay. Yeah.
They are the norm, and it is okay to make a repayment plan. And often those repayment plans can run as long as a year or perhaps longer. They have to be affordable. So I don't recommend anyone getting behind in the rent, because catching up is always difficult if you're low income. Do not hold your rent. Do not stop paying your rent. Get legal advice instead. Yes?
Okay, I'm so sorry. Yeah, to interrupt, but anyhow, okay. So I get like $1,155 a month, okay, and I pay $885 in rent. Then you knock it up to like hydro, maybe it's another 100.
Yeah, I
right?
know. I know.
So
Well, that's where these rent subsidies can really help, because if they can provide you with a couple $100 extra towards your rent, it starts to become more reasonable.
but
But
who
I
do I
can't.
call? I mean,
Lanark County 267-4200. That's who you call. Okay. If you're not sure, you can also call the legal clinic, and we can provide you with a referral to the appropriate people. But I'd suggest start with Lanark County.
Okay, that is 274.
No, we
And
are
what?
6. Okay, so Lanark County is 613-267-4200. The legal clinic, and I'm going to give you this again, is 613-264-8888 and press 0. Okay.
Okay.
So keep in mind, Dawn, sorry, this is being live streamed. So I don't want to get into your personal circumstances too much. Okay. If you need some advice, I'd be happy to speak to you privately. Okay. All right. I understand.
So listen, okay. So if I call Lanark Township, and explain, where I'm coming from and, my debts and all that stuff. And
Yep.
Seriously, what can they do for me? Like nothing.
Actually, they can. There is a rent subsidy program that you can apply for, and they would give you an extra several $100s towards your rent. You need to apply for it if you're that close. It's a great program, and it's saving a lot of folks, making it possible. The other option is a person can take a roommate at any time. Your landlord cannot prevent you from doing it as long as you're still living there. So landlords will tell you can't take a roommate, but you can. It's not grounds for eviction in Ontario. So not everybody's set up for a roommate. If you're in a bachelor, it's going to be very, very challenging.
Well, I guess so, but here's the deal. After all of my expenses and everything, I'm sitting at 21%, of billable income. I just can't live on that.
Yes, I understand. The other thing you can call is, you can call your local politicians, ask them what they're doing about the housing crisis. Yeah, I'm going to have to move on, Dawn.
I've done that. I know.
Okay. Yes. I'm going to have to move on, Dawn, because there's quite a lot more we'd like to get through. And if you'd like to talk about it later, I'd be happy to talk to you.
That's good. Okay.
Thank you for your questions, though, because these are the real challenges that we're all facing. It really is terrible.
Thank you for the information you gave me. Yeah.
Okay, I've got more, so hang in there. Another good question from Vicky says, when one takes on a roommate, who's the landlord of the roommate? If you take a roommate, you are the landlord of the roommate. Yeah, it's kind of a weird situation. We've got a stack of landlords. You got your landlord, and then you become the landlord of the roommate. So if the roommate didn't work out, unless they're put on the lease, you are the landlord of your roommate, and you can ask them to leave if need be. But be careful, because it can be complicated having a roommate leave. The law it's a kind of a difficult area of law, and there are big disputes about whether you can ask your roommate to leave. But generally speaking, if you are the only person on the lease, you can ask your roommate to leave if it doesn't work out. Yeah. So Mayor Pankow is indicating that there is a development proposed for Chambers Street. So that's amazing, and that's what we need. What we really, really need is more low-income housing. I mean, we really, really need subsidized housing. That's the solution. I'd love to see rent control between tenancies. There was such a thing in Ontario several decades ago, more than several. There used to be rent control between tenancies. The biggest problem right now is that if you move out and you're paying $850, your landlord can ask the new person to pay any amount. That could be $1,500 these days. And if you're moving, you're also in a situation where your new landlord can charge you any amount that they choose. So that's a huge problem for a lot of folks. And we're seeing it during COVID, it's just been, well, I mean, everybody knows that the rents have gone up so much, 1.5 to 2 times what they were, I'm guessing. And again, that's an estimate. Okay, let's go to the next. Page. Eviction process. So just to clarify, this is the only process. There is no other process. You must first get an eviction notice. It has to be on a Landlord Tenant Board form. I call it a warning. Nothing automatically happens. Do not move out just because you get one of those. Then in some cases, you're entitled to a second notice saying you did not correct the problem or the problem has recurred. That is primarily if you've damaged something and you haven't fixed it, or you're noisy, or you're causing trouble in the building, or you're causing trouble for the landlord, that sort of thing. You have a chance to correct the problem. If you do not correct the problem, or the problem happens again within 6 months, then you don't get another chance, except at the Landlord Tenant Board. Stage 3 is you get a notice of hearing and you have a chance to explain yourself at the Landlord and Tenant Board. Definitely get legal advice. It makes a big difference. At the Landlord and Tenant Board, they will decide whether it's fair to evict you or not. We'll talk about that in a minute. Finally, if the Landlord and Tenant Board feels it's necessary, then you will receive an eviction order, a formal order saying Landlord and Tenant Board of Ontario, explaining all the reasons and the process. Finally, the only way to be removed would be to get a notice from the sheriff. It's called a notice to vacate. We'll talk about that in a minute. They will say, we will be back in about a week. And at that time, your locks would be changed and you'd be asked to leave. It's a long process.
Okay. Hey, it's Don here.
Hi.
What about the winter months?
Okay.
They cannot evict you.
That's a good question, Don. Everybody for the last 25 years has asked me that question. It has never been the law in Ontario that you cannot evict people in the winter months. The sheriff works 12 months of the year. So does the Landlord and Tenant Board. It's called a myth. It's an urban myth or a rural myth. Everybody believes it, and it was never true. There was never such a rule. In fact, if there was such a rule, Don, it could mean that from October to March, you could stop paying your rent without fearing any repercussions, and that is not true. Okay, you can be evicted in the winter.
Okay, thank you. Thank
you.
No
problem. Good question. Good question. Next page, please. All right, I've given you the real McCoy here. Now this is the actual what a notice looks like. This is the only legal kind of notice. Now this is an N4 for non-payment of rent, the one we see most often. They all look kind of like this. They're called an N4, an N5, an N6, and N7. There are N9s and 11s, and there are N13s. Okay. If they don't look like this, then they're not an eviction notice. A handwritten letter saying we're tired of you, we're selling the house, anything at all is not an eviction notice. As you see, a landlord must use this form. There is no other form, and it is but a warning notice, a legal warning notice. Pay your rent, change your behavior, fix it, and stay. Don't move out, fix it, pay your rent, even make a small payment towards your arrears, whatever you can do, because it's not too late. This is what it looks like. Anything else, not an eviction notice. The other thing I'd say to you is a lot of these eviction notices are not filled out properly. And the Landlord and Tenant Board is very, very picky about these notices. The law says they must be filled out properly. And if there's a mistake in the date, if there's a mistake in the amount you owe, if there's a mistake in the address, etc., they will be thrown out when they arrive at the Landlord and Tenant Board. So do not give up hope and get some advice, because we can predict whether you're going to succeed or not succeed at a hearing. Next page, please. Mediation. Mediation is always offered, or almost always offered, at the Landlord and Tenant Board. It's an opportunity to sit down and solve the problem. Make a rent repayment schedule. That's very, very common. Make an agreement to repair any problems. Make an agreement about behavior. Make an agreement about barking dogs. damage to your apartment. Maybe there's disability related issues. Maybe an individual has a disability that makes it impossible for them to comply with the rules. That can be subject to an agreement to sort things out. And you can have a worker, a family member help you. You can always ask for more time. You may even be given money from your landlord to allow you to move out more reasonably within a more reasonable period of time. At the bottom, in typewriter print or whatever you call that down there, it does say, be careful. If you do a formal written agreement, a mediated agreement, and you don't follow what you agreed to do, you could be evicted without a hearing. There is one more form you can file to explain why you couldn't do what you said you did, why you should be given one more chance. But be careful, do not make an agreement for something that you cannot do. So one of the things we frequently do is change the repayment agreements. Someone comes to us and says, I can pay $500 extra a month. And I say, okay, how much do you make? Let's talk about that. And then I realize there's no way you can do it. So we say, how about $100 a month for the next year and a half to catch up? So that's reasonable. Okay, it has to be doable. If you make an agreement, or if your landlord wants to make an agreement that is not reasonable, get legal advice. We know what's reasonable. Okay, we've seen these agreements. We know what's possible. We know what's likely to happen when you get to your hearing, and we will help you to make a reasonable agreement. And if you make an agreement and break it, get legal advice immediately. There's often one more chance to solve the problem. Okay, hopefully that's helpful. But mediation is recommended. It's great. Always better to maintain a positive relationship. Fix the things. Nobody's perfect, and there are second chances. Next page, please. Okay. This is what landlord and tenant board hearings used to look like, something like this picture up there, except that usually there's more people waiting. Okay, pretty informal, one person, not a fancy judge in a robe. This would be somebody giving her documents to an adjudicator at the landlord and tenant board. It's not that fancy. You don't have to wear a suit. You don't have to have a lawyer, that's for sure, and you will be heard. And then the board must consider all of the circumstances. They look very, very carefully at the forms the landlord has filled out, and they will want to know exactly what happened in great detail, whether or not that actually fulfills the grounds set out in the law, and whether that case has been proven. So folks that go to the landlord and tenant board need evidence, they need witnesses, they need documents. If you bring the case, you need to prove it. If your landlord brings the case, they need to prove it. And then they consider how serious was the problem. If there was a problem, how much is owed? How dangerous was the tenant's behavior, or how disruptive was this person? And is there any way of fixing it? Are there any disabilities? Are there any special circumstances? The other thing they will consider are whether your landlord's intentions are genuine or whether they're trying to pull a fast one. Okay, is there another motive? Is something else going on? Are they asking you to leave because they don't like the look on your face? Are they asking you to leave because they know they can double the rent? They will consider all of that. The landlord tenant board is pretty fair. Okay, especially if you're prepared when you get there and you tell your story. They will want to know, do you have children? How long have you lived there? Where's your income coming from? How's your health? Is there something else going on? Has the landlord broken the law? If the landlord has broken the law, is in serious breach of their responsibilities, the board is not allowed to evict you, even if you've done something serious. So if your landlord has done some very serious things, they will not evict you. So at the bottom, it says the board will only evict you if it's necessary and fair. And many, many tenants get a second chance to fix things and stay in their home. Your home is protected under the law in Ontario. You may not own it, but you're still protected. So I've got my little second chance, next exit. There are second chances, and my best advice is don't give up. Get some advice and find out what's reasonable. Okay, any questions about that? Anybody? Oh, I will talk a little bit. These hearings are now online. I'll talk about that in a minute. What's going on since COVID? We'll talk about that later. Any questions? I guess not. Okay, let's move on then.
Well, there's a question
Oh.
here. Okay, Don again.
Yeah, lots of questions. Go ahead, Don.
Okay, well, it's okay. Now the rent program, okay, that's been stifled there because of, COVID. So are landlords now able to, increase like to what, 3.5%?
Good question. So for 2021, the maximum rent increase was 0. And we'll talk about this in a minute, but for 2022, the maximum rent increase is 1.2%. So if your rent is $100, the maximum increase is $1.20. You can do the math. Okay.
Gotcha. I heard
2022.
3.5. Okay, that's great to know.
It's not 3.5, it's 1.2. I'm going to talk about that later though, Don. Okay, so we'll try to stay right on the issue.
That's all right.
Okay, next page, please. Okay, here's the sample, not from our area. So somebody's name is on there. I don't know this person. I got this off the internet. Don't even know if it's a real person. This is a real sheriff's notice. This is the only sort of sheriff's notice that exists in Ontario. If it doesn't say, I don't know who this Arnold Gettle guy is, but if it doesn't say notice to vacate, it's not a sheriff's notice. Until you have one of those, you don't have to move. Okay. If you're not sure if it's a sheriff's notice, call me, I know, but that's what it looks like.
Well, I have a question there too.
Okay.
Excuse me, being in Ontario, I mean, we don't have sheriffs, okay?
Yes, we do. We absolutely do. 100%. We have a sheriff. You do. They don't wear a sheriff's badge. They might wear some, they do wear a uniform. So we do have someone called a sheriff, and that's a great question, Dawn. They work at the courthouse. In our area, you will see the sheriff if you want to say hi at the Superior Court of Justice I believe it's on Drummond in Perth, and you can walk in and say, I'd like to speak to the sheriff. And there is such a person, and they're responsible for carrying out evictions. They don't ride a horse and they don't carry a gun. And they don't have
that.
I'm joking.
I'm a former police officer. Yeah.
Yeah, but we do have sheriffs, and they're the only people who are entitled to remove a tenant in Ontario. Well, and this is how they do it. Yeah, do.
Thank you very much.
No problem.
Great.
So illegal evictions, this is very important. If your landlord is saying, I am coming back with the sheriff next week, or I am coming myself with a locksmith, I'm changing the lock, I'm throwing your stuff outside, I'm fed up with you, and it happens. First thing, if it's about to happen in 5 minutes, call 911. The police will prevent that landlord from throwing you out. They know this. They will defend you. Whether they like you or not, they will defend you. Okay, because they know this stuff. Secondly, call us.
Understood. That's correct. Yes.
Yes, and call us. Okay, and then the rental housing enforcement unit. The number's on the screen. If you're on a telephone, it's 1-888-772-9277, and you can call my office anytime and pick up that number. The rental housing enforcement unit is out of Toronto. I call them the housing police. Okay, they lay charges against landlords who throw people out on the street without a sheriff's notice. Okay, and I use that office quite frequently to ensure that illegal activities do not occur between landlords and tenants. Okay, so
yeah, I'm sorry, I got to cut in. Here's the deal. Okay, they throw people out of the apartment or whatever. I mean, winter's coming up. What can they do? What recourse, is available?
Okay, so that's a very good question. The short answer is call us before you're thrown out on the street. I think I have managed to stop every single one of these I've been involved in. As a lawyer, I can threaten them all sorts of things. Lawsuits and charges and all sorts of different things. Okay.
Right.
So most landlords back down. The other thing is we call the police and have the police visit the person and tell them, oh, no, you don't. that's an offense. You can't do it.
Well, I've done
Okay.
that. Yeah.
Okay. So Don, by the way, you're not the only person on the call. No offense there. There's lots of other folks. So we'll just stay on the topic here.
Whoever else is out there, they're not speaking up.
No, I know. And I'm glad somebody's talking. But anyway, just give me a moment, okay?
Sure.
So if an illegal eviction is about to occur, it can usually be stopped by early intervention. Otherwise, the gentleman, or well, I won't call your landlord a gentleman if they throw you out on the street without proper processes, but that individual can be charged under the law. Okay. The other thing is we've occasionally made enough noise that after someone is thrown out, we actually got them put back in. So that is possible, but I'd prefer not to have to do that because it's pretty hard. Okay, so anyway, the long and the short of it is it's illegal to throw people out without proper process. You can be charged, and this is the only notice. That means you really, really have to go. And if you get one of these and you didn't go to your hearing and you didn't do anything, you didn't defend yourself, you can still get legal advice and you still have a chance of staying. It's not too late.
Okay. I'm sorry to cut in again. That's all well and good. However, a poor person gets kicked out. Okay, he can't afford the rent and that stuff. So what does he do?
Okay, so Don, I'm here to talk about the legal process. I'm not here to talk about building shelters. I'm not here to talk about building more affordable housing. I mean, folks end up living with friends or family. Folks end up calling Lanark County and seeing if they can get a placement in some sort of emergency housing. It's everybody's worst nightmare, and I don't have an answer to that. Okay, there are services available though, but the services are not enough. Okay, but I can't fix that. Okay.
No, you can't fix that.
The best thing to do, Don, is to get advice early and to defend yourself before you're on the street. That's the best thing to do. Okay, I'm going to have to close this topic. I cannot change the housing crisis in Ontario. So the best thing we can do right now is stick to our guns, work together, support each other, and see what we can do to build more reasonable, affordable housing.
Okay, well, the reason I'm on here, okay, is being subsidized housing, rent to income. I'm looking at, somewhere to talk about that because I cannot afford my rent.
Don, it's Sean. Can you connect with me offline? Give me a call and we can talk about this. Maybe there's some ideas I can hit. So I'll give you my number, 613-430-9037. We'll let Linda focus on the things she can focus on today.
Again, what was that, Sean?
613-430-9037.
Thanks. Okay.
Will do. So, thank you very much.
Yeah. Sure. I mean, the reality is, Don, that these are the big questions. You're asking the right questions, but maybe not in the right place. Okay. We're all worried about this. We're very worried about this. And in the short term, just a moment. Yep. Just a moment. In the short term, I am suggesting that nobody move. Fight. Not in a bad way. Defend yourself. Okay, I'll talk about that in a minute. Can you turn the page, please, Carrie? Thank you. Is it okay? And you can give Mayor Pankow a call afterwards. This is the point. Okay, just what you were raising. Every eviction means increased rent for the tenant who leaves and the tenant who moves in. Both of them. Every time a tenant moves out, your rent could double. Rent control only covers you when you're in your housing. When you move out, there's no maximum. Increased rent equals more homelessness, okay? Eviction order equals increased rent. This is the big problem. So don't move. Do everything you can to stay in your housing until more affordable housing becomes available. Okay. Is there a current freeze on rent increases? Catherine. Yes, Catherine. In 2021, there is a 0% rent increase. It's frozen. But in 2022, it's going up to 1.2%. Nice and low. Sorry, not 1.2, 2.1. Going backwards. 2.1%. So that means, I think I said 1.2. No, it's not 2.1. It is 1.2. I'm sorry. I'm losing my mind here. It's 1.2. So $1.20 for every 100 you pay next year. And you got to get 90 days notice. But that's only if you stay in your housing. If you leave your housing, they can do whatever they want. Next page, please. Okay, legal action is possible. Eviction orders are appealable right up until the sheriff arrives. Even if the tenant didn't go to their hearing, there's an eviction order already, the tenant made an agreement and didn't follow it, and the sheriff posted a notice to vacate for tomorrow. All right, it is still possible to call the legal clinic, and it is possible for us to file forms and get a stop order, also primarily known as a stay, and send it over to the sheriff. And I'll tell you that the sheriff is quite relieved not to have to change your locks. I don't get paid by the case. We are the only free service for tenants in this community. Please don't email me directly. You can if you have to, but call my office and press 0. We have someone on the phone ready to take your call and ready to assist you so that I can jump into an action. And our intake staff are trained in prioritizing cases. The more serious the situation, if the sheriff is coming, they will call us immediately to jump into action. And if I'm on holidays, one of the other lawyers will do it immediately. Yep.
Okay, that's fine. What's your number?
613-264-8888. Okay, and press 0. That's the hotline.
Okay, that was 613-264. Right.
8888. Press 0.
Okay.
And this cartoon, I know you can't see it, all of you, if you're on the line, is represents sort of how I feel about all the work I've had to do in the last couple of years. I'd like to plead insanity, Judge. The judge says, on behalf of your client, no, he's fine. So anyway, it's been pretty crazy. We're ridiculously busy. I am busier than I've ever been in the last 21 years of working here. There are more eviction applications going on right now than there have ever been, sadly. Okay, so next. Dawn.
Where's your office? Charlton Police or Perth? Or
Perth.
Okay, good. Right.
Okay, next page, please. Okay, here's my general advice. What to do? No matter what, keep paying your rent. If you can't pay your rent yourself, ask somebody else to pay it directly for you, whether it's ODSP or Ontario Works or anything. If you get behind in your rent, there is a program in Lanark County called the Housing Options Program. They can pay some rent arrears for you. Pay your rent. I don't care whether the ceiling's falling in, please pay your rent and then call me right away and we'll do something about it. Get legal advice when things get difficult. Call the legal clinic. It says call the legal clinic with the client. I originally wrote this for a staff training I was doing for an agency. I did the same training with ODSP. I've done trainings with Ontario Works, and I'm going to keep doing trainings until we're all on the same page. Put all your communication with your landlord in writing. Text your landlord. Keep a record. Text and email are great if you can do it. Don't argue. Don't make it worse.
No.
Get some advice. Yeah. Okay. Fix the problem if you can. Catch up on your rent. Be careful. You've got a time limit if they say fix it. Thank you. Okay. Fix the problem if you can. Be the better person. I always tell everybody, be the better person. Be quiet. Control your animals, control your children to the extent that people can. You don't have to tiptoe. Fix things you break. Respect your neighbors. Be a good person. I know we are all decent. Try to avoid arguments. It doesn't help. Okay. Even if you're really, really stressed out, vent to somebody else. Vent to me. I'll listen. I don't mind. Prepare for a hearing. Keep all your documents. Do not rip up your notice of eviction, no matter how much you feel like it. Get advice. Don't sign anything. I don't care what it is. Don't sign anything. Even if they offer you $10,000, don't sign anything.
That's correct.
It's true, because that $10,000 will not keep you housed for the next year. Just a moment, I will answer the question. And don't move out unless you have a cheaper and better place. So a quick question was, what if the landlord sends the rent back and doesn't show up to pick up the rent? Great question. Common problem. Landlord wants you to get behind. Number one, if you have an option to have your rent paid directly through social services, ODSP, or any other way, do it. Alternatively, e-transfer your rent to your landlord, then you have proof you tried to pay it, if you can. If not, text your landlord and say, the rent is here, come and pick it up. You need a paper trail showing, I tried to pay my rent. They didn't want it. Make a paper trail. And whatever you do, don't spend the rent. Put it somewhere where it will be safe, because if your landlord says, I don't want any more rent, 8 months from now, your rent arrears are going to be $8,000 or $10,000. And if you spent it all, it's going to be a lot more difficult. So it does happen. Now, if your landlord is refusing rent, please get some legal advice, because things are broken down to the point where they're trying to evict you. But I say e-transfer them. If they don't want to pick it up, you have proof. You're not going to be evicted because they refuse to accept the rent. Not likely. But please don't spend it all in the meantime. And I know how hard that is. Okay, I hope that answers the question. Next page. Okay, other legal issues. So now we're going to get on to some of the other things oh, here's a question. Can a landlord demand that you pay through automatic payments? I'm going to get to that in just a second, okay? Good question. These are the issues I'm about to talk about, and I'm going to go through my thing. So just so you know, I'm going to talk about tenancy agreements, how to pay your rent, rent geared to income, repairs, privacy, tenants duties, discrimination, and a bunch of other things. So I've already talked about some of them, but we'll go through these things. Next page, please. Tenancy agreements. Okay, I'm going to be quick on this one, but a tenancy agreement in Ontario should be on the Ontario standard form lease. There's only one legal lease in Ontario now. If you signed something else, that's okay, but you still have a right for an Ontario lease. If you ask your landlord for an Ontario lease, they do have to give you one. It doesn't mean you're not a tenant, but the new standard form lease is the law in Ontario. Okay, the reason it's the law is so that, okay, can we mute? Can we mute Dawn, please?
I'm sorry. I was interrupted there.
Dawn, can you push *6 on your phone just for now? *6.
I'm sorry again, what was that?
Push *6 just for now.
*6.
Okay, if you can't do it, we'll try not to interrupt. Okay, tenancy agreements, standard form lease in Ontario. The reason there's a standard form lease is so that your landlord doesn't put a lot of illegal things in there and everybody knows what the rule is. Okay, so there are certain things that are not legal, such as no pet rules, no roommate rules. Answer, I just got a question. If you're renting month to month, does the landlord still have to use a standard form lease? Yes. Everyone who is renting, except for a room in your house where you share the kitchen and bathroom, standard form leases are the law in Ontario. Okay, and if you haven't seen them, go online and put in Ontario standard form lease and you'll see them. If you don't have a standard form lease, that's okay. You're still a tenant. You have all the same protections, but it's better to have one that actually sets out the rules. So any section in a lease that's not a standard form lease that is illegal it's as if it doesn't exist. So if it says they can evict you for any reason on 30 days notice, nope. If it says there's extra fees, like for, I don't know, if late fees, they're illegal, nope. Anything that's in your lease that's illegal doesn't count, it's canceled. They cannot prohibit guests, roommates. They cannot prohibit normal use of the home. No smoking rules are acceptable. They should be in your lease. No pet rules are not acceptable, but your pet has to be properly cared for. And once you sign a lease, if it's a legal lease, that is the permanent arrangement. Even if it's 20 years from now, same deal. Somebody asks, what about utility caps? So there is no cap on utilities. So if you are to pay your utilities directly, if you pay the utilities directly, that's permanent. If utilities are included, then they're part of your rent and they do not change. So your rent is subject to the maximum rent increase. If utilities are included, not your problem. So they can't charge you extra for utilities. So if my rent is $8.50, that would be nice. And utilities are included. And if my lease says if somebody else moves in, I have to pay extra utilities, nope, utilities are included. So utilities are, if they're part of the rent, you can ignore them, they're part of the rent. And if they're extra, they're your responsibility. Well, let's see if there's another question. Air conditioning is an exception. You can have an air conditioning amount. It's often $50 a month or 25 but only if your hydro is not paid by you but is paid by the landlord, then hydro, you can have an extra charge for parking and you can have an extra charge for air conditioning. That's specifically set out in the Residential Tenancies Act. Somebody also says, I heard landlords cannot bill for water. Yes, they can bill for water, as long as it's specifically for water and not water, sewage, etc. Okay, so the sewage charge is part of their taxes. The water comes on the tax bill sometimes. They can charge you for water if it's in your lease. But if you're on a well, they can't charge you for water because they're not paying for it. Okay, so it's okay to charge extra for water. April asks, are my rights any different if I never had a lease? Simple answer, nope. Your rights are just the same. So you have all these protections regardless. Yes, that is the law in Ontario. So no matter what your landlord writes up, even if it's the strangest lease you ever have seen, and I've seen some pretty weird ones, and I've seen some really excellent ones too. But even if you have a very strange lease or no lease at all, you have all the same protections. Yes. Next page, please. Oh, and the final thing about leases, once you sign that agreement or make that agreement oral or otherwise, it cannot be changed, okay, unless the two of you voluntarily agree otherwise. So if utilities are included, they will be included forever. Okay, maintenance and repairs, no excuses. Here's a lovely home for rent on the right-hand side. Glad to say, not in Smiths Falls, and I actually don't know. It's not a home for rent. Basically, the deal is this: landlords must maintain and repair all properties at all times, and no excuses. Okay, every single municipality, township in Ontario has property standards. They're either set out in a property standards bylaw, like Smiths Falls has, or if they don't have a property standards bylaw, then there is a Ontario provincial bylaw or Ontario provincial regulation that sets out property standards. Basically, the deal is this: the place has to be up to standard at all times, not necessarily the building code, but everything must work, must function, windows open, screens in, even taking care of things like bed bugs, cockroaches, and mice. Now, the landlords can only do it if they know about it, but every place that you rent is required to be up to standard. But if you break it, you are responsible to pay for it or fix it. Your landlord must deal with mold issues. They must deal with old roofs. They must deal with anything that will affect your ability to live safely in your apartment, safely and reasonably in your apartment. They don't have to paint and wallpaper though. Okay, it just has to be functional. There are lots of people out there to help you. The town of Smiths Falls and all our other towns and municipalities have a property standards inspector. They will come out. They can issue work orders to bring the place up to code. We have a fire department in every community. The fire department will come out and inspect for safety. They can also issue work orders. They might even bring you a new smoke detector. They're really nice about that. Okay, I think they found that it's easier to give you one than to argue about it. We also have an authority called the Electrical Safety Authority in Ontario, and they will come out and inspect if there are serious electrical issues. Great resource. Don't call them unless you're sure there's safety issues, because they will bill your landlord for the visit. So don't call them unless you're pretty sure it's needed or it's recommended to you by the fire department. And of course, you can apply to the Landlord and Tenant Board for an order requiring repairs, reducing your rent, paying your expenses, and paying you penalties, etc., and maybe even fining your landlord if they refuse to fix the place. So my advice to you is don't stop paying your rent. Do something about it. Call somebody. But before you do it, please write to your landlord and let them know, because if there's a serious problem and you don't tell your landlord about it, you could be to blame for that. So if there's a leak coming through your ceiling and your landlord isn't told, they may decide to blame you for not telling them. So call them first and put it in writing. And text messages are great. Finally, if all else fails, our friends at the Rental Housing Enforcement Unit, I call them the housing police, can charge your landlord for refusing to maintain a property. But usually that's the very last step after applying to the Landlord and Tenant Board. Okay, any questions about repairs and maintenance? It's a huge area. Is there a response time that landlords need to be held accountable? Very good question. Simple answer is no. But it depends what it is. If there's a fire, the response time after you call the fire department is right away, or a major flood. If it's a light bulb out, then, well, first of all, fix it yourself. But if there's something more serious, it could be a couple weeks, it could be a month. It depends how serious it is. Yes, Mayor Pankow.
Yeah, thanks, Linda. I've had numerous people reach out over several years complaining of infestation, usually cockroaches or bed bugs.
Yep.
And so, to my understanding, it's not the health unit doesn't respond. It's not a health unit issue. It doesn't fit well within our property standards bylaw, but I understand it fits under the landlord tenant responsibility. So, in these situations, if they have a landlord who is not responding to the infestation and it's coming from another unit, should they call the legal clinic?
Yeah. So the basic rule is almost every town or township, and no offense to Smith Falls or anybody else, has a property standards bylaw that says a unit must be free from vermin and infestations. So they do vary a little bit. And if it's not in the bylaw, I certainly recommend that it should be in the bylaw. Bed bugs and cockroaches and other infestations can be very serious, and they can spread throughout our community. And I'm sure that you know that very well. But most municipalities have that very clearly in their bylaw. It is true that the health unit for the moment hasn't got the resources to deal with those sorts of things, and they're not considered an extreme risk to health. They're more of a nuisance. A landlord is only required, so quite outside of the property standards bylaw, a landlord should deal with anything that can impact your ability to live comfortably in your home or interfere with your enjoyment. That's a legal term. So I can tell you bed bugs will interfere with your enjoyment tremendously. I've dealt with them in many properties, and it's a nightmare. And the Landlord and Tenant Board takes them very, very seriously. And I would hope that all the property standards bylaws should prohibit serious infestations. But at the same time, I would tell you that landlords are only expected to do what's reasonable to deal with it. Nothing is perfect. I live in the country. Yes, I have mice. Sometimes I have cats. You can't get rid of all the mice. And sometimes you can't get rid of all the cockroaches or bed bugs, but you sure can try. And so landlords are expected to do what's reasonable. And that includes making the other tenants do their share. It's a joint effort. Mice, maybe they just give you traps. I mean, they don't have to give you a cat, obviously. They only have to do what's reasonable. But yeah, if there's a serious infestation, you can let me know about it, and I'll do what I can. But our priority right now is preventing evictions. So there is a limit to what we can do. We are stretched beyond what we've ever been stretched before. Good question. Next page, please. Paying the rent. Well, we've talked about this a little bit, and it's 1.2, yes, for 2022. So expect a little rent increase perhaps, but it's not very much. There are no catch-up years if you miss a year. And they got to give you 90 days. They're supposed to use the proper form. I usually say, don't sweat the small stuff. If they give you 90 days and it's the right amount, I don't require the proper form. Technically, you could require the proper form. If you started paying an illegal rent increase of $100 or $200, you can stop, but you need to do it within a year. If you keep paying, there'll be a time limit on arguing about that. So if you find out that you've paid an illegal rent increase, you should stop and get some legal advice right away, or live with it. And sale of a property or getting a new owner does not change the rent amount. Your rent stays the same, subject to your 1.2 for 2022. Okay, we had a question earlier about whether landlords can require a specific form of payment. Simple answer, no. Any form of payment is fine. They may not want to give you the personal banking information, but some do. Some will allow you to go to your bank and deposit directly into their account. If you're going to pay cash, please get a receipt. It is the law they must give you a receipt. And if they don't want to give you a receipt, then you might as well flush it down the toilet. Because if you can't prove you paid your rent, you're going to have a real problem. I suggest go to the dollar store, buy a receipt book, fill it out yourself, and ask for the signature. Perfectly legal way to get a rent receipt, as long as somebody else's signature is on it, the landlord's signature. Okay. And then extra fees are illegal with a couple exceptions. Parking, air conditioning, but only if your hydro is included. And the cost of a key, okay, so a key is less than $10. A key deposit of more than the cost of a key is illegal. The only security deposit is 1 month's rent. Damage deposits are illegal. Making you pay 2 months rent plus your first month as a deposit is illegal. They cannot ask you for 3 months before you rent the place. That's illegal. If you find yourself in a situation where somebody's asking you to pay a fee that's not legal, here's my advice. Go ahead and pay it. Take it off your next month's rent. Because unfortunately, when you argue with the landlord before you move in about something like that, they'll probably find somebody more agreeable. So I would just deduct. If you found yourself paying a fee that you shouldn't have paid, then just deduct it. But write a note to your landlord. Deduct it later. That's my advice, because arguing with a person before you move in about whether pets are legal and things like that, probably not a good idea. It's a landlord's market right now, sadly. But there are not a lot of extra fees that are legal. So bounce check fees are illegal if they're out of pocket. Late fees are not legal. Yep. Okay. Next page, please. Rent geared to income. Not going to get into this too much. It's a big area. Suffice it to say that rents in rent geared to income or Lanark County housing or Carebridge or Tayside or some of the places that are listed here, typically 30% of your income, or there is a set amount if you're Ontario Works or ODSP. I think if you're on ODSP, your rent is $222. It's a good amount. So put your name on the list if you're low income. There is no priority to get into housing unless you have been a victim of domestic abuse. There is no priority for homeless folks, unfortunately. And that is an Ontario government rule as well as a local one. But other than the 30% of your income as rent, all the same rules apply to rent geared to income housing. Now, there may be a few exceptions. I'd be happy to give you the details, but all the same landlord tenant exceptions apply. Place has to be up to code. They still have to give you 24 hours notice of entry, all those sorts of things. And there's a link there, or you can call Lanark County Housing if you'd like to apply to Lanark County Housing. Next page, please. Be quick here. Tenants have a right to privacy and peaceful enjoyment. That means landlords can't come in, but except for with 24 hours written notice for proper reasons, such as repairs or inspections. Not to argue with you, that's not proper. If this gentleman in the picture who's yelling comes to your door, that's not a proper reason to come in. I would hope nobody ever treats anybody like that, and don't be that guy. Okay. So it's not illegal for your landlord to knock at your door, and you can let them in if you so choose. But if they give you 24 hours written notice with a date, time, and a reason, you must let them in, unless you can convince them to come at another time. In the top right-hand corner, we have an example of ways you might annoy your neighbor. Don't be this person. Don't play your electric guitar, and don't whack on the wall. Okay. You can be evicted for those things, and you have a right to privacy, and you have a right to quiet within reason. The other thing is your landlord cannot, for any reason, turn off your heat, hydro, or water. You have a right to those things at all times. They can't do it. They can be charged for doing it. It's not legal. They can also be charged for coming in without notice unless it's an emergency. If there's a fire or a flood, they can come in. And you can apply to the Landlord and Tenant Board for compensation, for an order. Landlord can be charged and fined if they do break any of these rights. You also can be evicted if you are the person causing the issue, of course. But again, subject to everything I said about the Landlord and Tenant Board's responsibilities to ensure it's necessary. Next page, please. Tenants' duties: pay your rent on time. Landlord Tenant Board believes that you shouldn't hold your rent even if there's a lot of problems. I disagree a little bit, but the general advice is you should pay your rent regardless. Here's a question that we got earlier about normal wear and tear. So it says tenants be like, and then there's graffiti everywhere, and oh, but that's normal wear and tear. Probably not normal wear and tear. You're responsible for paint and drywall if you wreck your place. You certainly do have to repair damage that you cause, or your kids cause, or your dog causes. You do have to let your landlord in with 24 hours notice, even during COVID. It is considered an essential service. You can ask them to wear a mask, you can social distance, you can use sanitizer, you can tell them to minimize the number of entries, but they can still come in and do repairs. And you cannot change the locks. Now, I take the position that tenants can do some simple things to protect themselves, like ask the landlord to put a peek hole in the door so they know who's there. You could probably put a small chain on the back of your door if you're not damaging anything beyond repair, just for your own protection. But if you're a landlord, your landlord has to have a key. You cannot change the locks without permission. And you must respect other people's peaceful enjoyment and privacy. You must not harass, bother, endanger other people in the building or your landlord. Okay, next page. Human rights complaints. This is a whole big area that I can't get into today, but discrimination on the basis of a protected ground like gender, age, even if you're 16, sexual orientation, family status, you're a single mom, you're a single dad, you're divorced, whatever it is, your background, whether you're an immigrant, whether you're from here, your religion, your disability, social assistance, you're on ODSP, they cannot use that as a reason to deny you housing. Believe it or not, it is illegal in Ontario to say, I won't rent to you because you're on ODSP or Ontario Works. That's illegal. It's a basis for a human rights complaint. Human rights complaints are very, very serious. You can complain, and we could explain to you how to do it, give you some assistance. We won't do a whole lot of it. We'll do some of it. And we know this stuff happens. There is a sign behind me that says discrimination is the leading cause of homelessness. Well, I'm not quite sure that's true, but it is a major problem. I think inability to afford the rent's probably now the leading cause. Failure to accommodate your disabilities. Your landlord has a duty to accommodate your disabilities. They have a duty to put in ramps. They have a duty to allow you to have a caregiver. They have a duty to allow you to park your scooter, all sorts of things like that. So if you have a disability and you have a disability related need, you have to work together with your landlord, make proper requests, seek other sources of funding. But if all else fails, your landlord actually has to pay to modify your unit and make it possible for the gentleman in the wheelchair to get down those steps properly, or for you to use your bathroom in safety. Grab bars, if you need them, are necessary. And your landlord cannot say no. Anyway, there are lots of things that the Human Rights Tribunal of Ontario can do if a landlord refuses to accommodate your disabilities or denies you a service because of any of the protected grounds. So believe it or not, I have a thing here that says adult-oriented building. It's illegal. The only age you can choose for an adult building is 65 plus. Any other limit is illegal. As soon as there's 55-year-olds in the building, it is not a seniors building. You can transition a building from a regular building to a seniors building, but only if the age is 65. So there's no such thing as a no kids building unless it's a 65 plus. Yep. And a lot of people don't know that. A lot of people don't know that. That's a big area. Next page, please. COVID. Okay, evictions are no longer on hold. We started up in August of 2020, and they have been going full speed ahead every single week. I have seen more eviction hearings in the last 12 months than I've ever seen in over 20 years of practice. It's ridiculous. I'm sorry. There's a huge backlog, and the backlog is pretty much cleared, except they're not hearing the tenant applications. So they have cleared up most of the landlord applications. They are now going through them very quickly. They did 3 days a week in our area of telephone hearings, often lasting all day since August 2020 until now. You will either have to go in by video using Zoom. So if you're here today, you know how to do it. There's a lot of other folks who don't, but you can also use the telephone. So you can always go in by telephone. Please do not miss a hearing. If you don't know how to participate, please call us. Duty counsel is available at every hearing. That's me or one of the other lawyers from our office. And in the meantime, so not too much has changed, except that now everything is by Zoom. So it's a really strange and new world. And if you've never used Zoom, then you need to get some advice. And I recommend you use a telephone or possibly come to our office for your hearing or use another public space. I don't recommend the library because you need your privacy if you're going to be at an eviction hearing for 5 hours. And it might be 5 hours or more. Unfortunately, the Landlord and Tenant Board is often having blocks of 75 cases being heard together. It is very busy, and you will go online and wait and wait and wait to be heard. So get some advice early. Your hearing may be very, very short if you're not prepared. But if you are prepared, it could be short and good. Anyway, landlords still have to repair. There is a new social services relief fund for people who may have lost their jobs or been unable to pay the rent because of COVID. Our legal clinic is operating. We are now back to walk-in service to some extent, but we don't always allow folks to come right in. We prefer people to wear masks. We are very concerned about COVID, and we certainly don't want to put anybody at risk. But we're up and running and everybody's back in the office, and we never stopped operating. So that's the COVID update. Next page. These are some options for services for tenants. Legal clinic, we've talked about that. 264-8888. Duty counsel, just go to your hearing and ask for duty counsel. That's usually me or one of my colleagues. Mediation is always available. Ask for mediation. Somebody will help you to sit down and figure out something. There are property standards available. It is considered, property standards inspectors are considered essential service workers. There is a HOP program, Housing Options Program, and another program to help people catch up on rent. It's only once a year. There is a program to catch up on utility bills, and there is a rental housing enforcement unit that can lay charges if need be. So we can talk more about that. If you're not sure, give the legal clinic a call or give your local municipality a call. Next page. Legal clinic. If you're on camera and you can see this is how to find us. I ask only that you press 0. If you don't press 0 when you call us, 264-8888, if you don't press 0, you don't get on the callback list. So please start with pressing 0 and give them all your information. Be patient with my intake staff. They're trying to determine what the priorities will be for any of us to call you back. If it's an eviction, you get higher priority. And if it's a small infestation of mice, you're probably going to be a pretty low priority. And sometimes we do home visits, sometimes, not as much right now. And but we can do so if necessary. We do have offices in Perth, Brockville, and Sharbet Lake, with some satellite offices, often in Carleton Place, Smiths Falls occasionally, and Northbrook out in North Frontenac. So we serve a big area.
Can you tell me where? I'm sorry. Can you tell me where the office is here in Carleton Place?
Okay, there isn't a regular office in Carleton Place. It's by appointment only, and it's at the Lanark Community Programs building at 30 Bennett Street, just north of Highway 7.
I'm sorry, 37 what?
30 Bennett Street, but there's no point in dropping in there. You have to call us. We don't have a regular person there. 264-8888, press 0. We will only go there if necessary, and during COVID, we haven't been going there.
Okay.
Okay, but if you need something, call us. Okay.
I will.
Okay. All right. Next page. I think we're done, but next page. Questions. Okay. What time is it?
2:44, Linda.
Oh,
Thank you
my
very
goodness.
much.
My goodness.
Perfect
I guess we have a little bit of time for questions. So are there any other questions?
Catherine Coleman.
Actually, you can close, Carrie, you can close the PowerPoint presentation now if you like. Thank you.
Go ahead, Catherine.
Yeah, so I actually just wanted a little bit of clarification to something you said super early on. But first of all, thank you. This has been a wealth of information. I'm so appreciative for your time. When you were talking about fourplexes, so let's say there's a situation where an owner is selling his fourplex, there's a new owner. Because it's a fourplex, they can't evict the tenants in that unit?
That's correct.
Wow.
It's illegal.
Okay, thank you.
And never do it. Yes, and the other thing is, here's another thing. Let's say it's a triplex.
Okay.
The landlord can't evict all tenants in a triplex unless they're going to knock down all the walls and live there as their primary residence. If it's a rental property, they can't evict those tenants.
Now, what happens if they were to say, oh, they're going to be doing some type of work that requires the tenants to move out?
First of all, call us, okay? Because there are very, very narrow reasons when that is possible. Send the folks to us because I'm working on these. This is a very high priority, okay? So there are very specific rules about when you can ask a tenant to leave because of repairs and renovations. It must be absolutely necessary. If I can stay in my house and let your workers work around me, I get to stay. Secondly, Catherine, once those repairs are done, I get to move back. I'm the tenant. I move back, same price. And they have to do the repairs within a reasonable time. No rent increases for me. Nice new apartment, no rent increases. Don't let this happen on your watch.
Okay, yeah, it's
illegal.
I had no idea, because I know a client who's in the process of, the house is being purchased and they were told that the new owners will be evicting all. So that is not the case. That is illegal. It's
illegal. And somebody else just asked, if you're saying, if you live in one of 4 apartments in a fourplex, can you be evicted because the landlord wants to move in? Answer simple, no. It's illegal. And if the landlord lives somewhere else, they live somewhere else. Okay, we're not talking about renovations. I mean, if it's renovations, they can move. They can take your apartment for a short time to do their renovations if they satisfy all the conditions. They have to have a work permit. It has to be a building permit. They have to have proof from their contractors that the repairs and renovations are so serious that you can't stay there. Okay, so it's not a question of whitewashing. Okay, if you're going to replace some floors and fancy the place up and make it look pretty, that's fine. But you get to stay there and make it look as pretty as you like, right? And the rent increase for 2022 is going to be 1.2% if they give you 90 days notice. So I'm sorry to be tough, but this is a very serious problem in our community, and not just our community, everywhere. The biggest problem we're having is, and you're going to get bad advice. I am seeing, and I'm sorry to say this, no offense, but I am seeing real estate agents, nobody in particular, but some of them are giving tenants very bad advice and saying, you got to move, the place is sold. Yeah, you're on mute, Catherine, but yes, indeed, I can see your face.
Enthusiastically agreeing with you. Yes, sorry.
Yes, I could tell from your face. Yeah, so first of all, your real estate agent is not your landlord. You don't work for your real estate agent doesn't work for you. They don't give you advice. And I say, let your landlord tell you what's going on. And you know the process. There has to be legal notices, legal processes, legal grounds. And if it's a building that's a rental property, it's a rental property and you're part of the deal. It's rented, it will stay rented. So I don't mind folks coming in and buying rental properties and fixing them up. That's great. But you don't have to go anywhere if you're the tenant in that building. So please don't encourage anyone to move.
Yes. So Linda, further to that, and no need to apologize. We appreciate your firmness on this, because it's people of our communities who are being evicted many times through the renovation strategy and completely.
That's right.
So if they receive an N13 and are advised they have to move out at a future date, no matter what, until they have an action from the Landlord Tenant Board, there's no evictions. The Landlord Tenant Board would have to determine that the renovations are so complex and so vast that the person cannot live there during the renovations. That
you got it. And they have to have their building permit in order, and they have to follow all the processes, including giving you a great deal. I believe it's 120 days. It's not 60 days for that. And they have to come and see me, because I fought a lot of these and we're winning. We're winning on them. I'm fighting these because this is the biggest problem we're having, because if they're going to fancy up the building, we know it's all about doubling the rent. And when I say doubling, they really are doubling the rent, or more, 1.5 or more. Yes. And I mean, I'm seeing vulnerable folks who've always lived here their whole lives, and it's just not right. It's just not right.
Yes, I know some that received N13s this week, and there are more.
Okay. These are exactly the people that need to come to us, and I'd be more than happy to talk to folks. And the other thing is, some of these folks are also, the landlords they're professional landlords. So if they don't have a home of their own, and by the way, I have resources. So, I don't have $1 million or anything. What I'm saying is I can search. You give me a name of a landlord and I'll search the land registry and find out how many properties they own. And if their name ends with a INC, in other words, they're incorporated, they can't do it at all. They can't do it at all. It's illegal. A corporation does not have a home. They don't live in a normal property for residential purposes. So it's not part of the act. You can't do it. Yeah. So it's very, very serious. And that's why these training sessions are so important, that we can all be vigilant and make sure that we're not encouraging people to move. Here's the other problem, big problem in our community. And I'm sorry to call people out, but what I'm hearing is real estate agents come by and they say, property sold, here's a paper, you have to sign it, agreeing to move out. And people are signing them. And they're saying, well, we'll give you a month's compensation. And by the way, they're required to give a month's compensation by law anyway. So here's a month's rent, sign here, we're good to go. I'm fighting those, even after those forms are signed, because they're illegal, they're based on misrepresentation. But don't sign anything, no matter what tenants do, no matter what you think it is, whether it's a receipt or an acknowledgement or anything, don't sign it. The only thing you should sign is a lease when you move in, nothing else, ever. That's my personal opinion. Well, you can sign a repayment agreement if you're a bit behind in your rent and you can afford it, it's fine, but nothing else. Yeah, so that's the biggest problem. Not only are we seeing this, but they're putting, instead of giving them notices, they're giving them agreements to move and saying, okay, I'll give you extra time here, sign here. And it's very sad what's going on. It's very, very sad. And it's every week I'm dealing with this. I'm sorry to be so strong, but this is reality. Okay, question. Yeah, well, you're welcome. Thank you. Anything else?
Yeah, I have a question.
Sure.
Tell you what, can you actually send a list of what is available for free, through legal services?
Yes, but I think you'll have to okay, you'll have to get in touch with us. Call the number 264-8888. I don't have your email.
Well, yeah, but
just
I'm thinking about
make a phone call, Don.
How do you know? Okay. Listen,
yeah, I can send it, but I don't have a magic way of sending it. So you need to phone us and give us an email address. And don't give me your email address right now because this is going on YouTube. Okay. Anything else? Yeah. And actually there is information available. I mean, the reality is folks at the town of Smiths Falls do have this information. Lanark County is the best place to call, actually. 267-4200 is the best place to call about resources. Okay. They're usually the central hub. Anything else?
I take it that I'm going to call Sean pretty soon.
Okay. He's giving you his information. So,
anything,
okay.
Any further questions for Linda? Shannon?
I'm seeing lots of nice thank yous. So thank you
Shannon,
to you
you're
folks
on mute,
as well.
You're on mute, Shannon.
Go ahead.
Okay. Hi, Linda.
Hi, Shannon.
Nice to see you. Thank you very much for being here this afternoon. I always find out something new every time I listen to you. I'm wondering, if you're in a situation with your landlord and you offer to do mandatory mediation, can they refuse?
Yes. Mediation there's no such thing as mandatory mediation. This is voluntary mediation, Shannon.
Okay.
Mediation is a voluntary process.
All right. If they have a lawyer that's representing them and you're offering to do mediation.
Yes, they can refuse. It's voluntary mediation.
Oh.
It's a collaborative process.
Okay, thank you.
Yeah, so simple question, simple answer, yes.
Thank you.
Yeah. Very nice to get all the thank yous. Thank you guys. Thank you to the folks that organized this. I apologize for the fact that it's not in person. I don't really apologize. I just don't want to put anybody at risk. And besides, I just wanted to say that Facebook has this great filter that gets rid of our wrinkles. And so, it has that a touch-up thing. So that's the real reason why I wanted to do this online.
Well, again, that might help a few of us, but again, I don't think we can thank you enough because, as you've mentioned through your presentation here, a person's home is the foundation of their health, and we know that if someone is at risk of eviction, there's a strong risk of becoming completely homeless. And we know that every time an apartment comes up now, there are usually 40 to 50 people who are applying for it, meaning the vast majority, 99%, are not going to get the unit. It's deeply concerning. And we know the most affordable home that someone has is the one they are in today. And thanks to you, thanks to people who listen today and how this will get widely circulated on social media, more people have a chance to tune in after the fact to learn. Your willingness to help is extraordinary. I know your passion, your purpose is second to none. And if there's an opportunity for you to keep someone in their home, you will do all you possibly can. And I guess we deeply appreciate that. And what you've done for us today will undoubtedly ensure that some people are able to avoid eviction, stay in their home, stay healthy, and avoid the stress of having to find a new home at a much higher cost than they're paying today. So on
Yeah.
behalf of everybody, on behalf of the Housing Advisory Committee and Town Council, thanks so much, Linda. We deeply appreciate all you do for us.
Well, and it's my pleasure. And my colleagues are also doing a lot of work here. So don't send them straight to me because there's a group of us. I also thank you folks at Smith Falls who are working so hard to actually find more affordable housing options, because that's one of the best things. That's what we really need. And that's where my hands are so tied. And that is going to solve so many problems because affordability is the biggest challenge we have right now. Really, really is. We're
committed to it. Unfortunately, it's a longer term process, but we do know there's some good irons in the fire.
That's a heavy lifting. So I'm just plugging holes here, but the Band-Aids aren't going to solve this. And the real initiatives that you folks are working on, that's going to get us out of this crisis in the long run, I'm hoping.
So thanks everyone. Appreciate your time and attention and curiosity and questions today. If anyone is not aware, just want to put a little promo out. We are having a Every Child Matters Truth and Reconciliation event tonight. It starts in Centennial Park at 6:30 over to Duck Island, where we have an incredible program where we have people, we have residential school survivor, as well as members of our Racism and Discrimination Task Force who are descended from residential school survivors. And it's going to be an incredibly insightful, educational and informative evening if you have a chance to get out. So again, thanks everyone for your attention today. Feel free to follow up with Linda as required, and you can always reach out to me if I can help as well. All the best.
You know what? I'd love to attend, but Lanark County Transportation, that's the only way I can get there.
Oh, sorry, Don. The last word was with Don.
Thanks, Don, thanks, Don, for all your good questions.
Yeah.
Well, thank you much, but I just want to say I'd love to go there, but Lanark County Transportation, I'm not sure if they cover that.
Okay.
Probably not, and certainly an appointment needed for that, I believe. But
that's anyway, we'll leave that for another day.
Yes. Take care, everybody. Enjoy the week.
Bye-bye.
Bye. You know what?